Okay, good evening. Here we are, Thursday, November 14th, 42 Action Law Call. So glad to have you guys on, and we love all the replays that we see happen every single week. The numbers are up, and these calls are getting shared, and the website's been passed all over this country, and actually we're seeing the hits come from other nations, and it's pretty exciting to see. We have a special guest who's going to be on just in the beginning tonight, and his name is Melvin Anthony. And some of you have actually met Melvin in person, but he's got a fascinating background, and he's busy in the law. He's filed a Title 42 in court, and he also has been a massive bodybuilder, the cover of several magazines, and he's got a video that's out there. Is that video still out there? The interracial couple on the airport deal? Okay, so you can give that information as well. So I'm so glad to have you guys on. A lot of you love Melvin. He's backed by popular demand. I was talking to him earlier today and said, come on out. And without further ado, Melvin, take the floor. I know you have a lot you want to fit in a little time. If you would, for the new ones, just give them a little bit of background on yourself and what your fights have been and what's going on.
Well, hello, everyone. Hopefully everybody's sitting down and comfortable. Basically, can you guys hear me okay? Can you guys hear me okay?
Yes.
Oh, okay. Well, basically, like you said, Randy said before, I am a professional athlete. I was in the sport of bodybuilding for quite many years, I'd say about 17 years, and just kind of got into the law stuff about a year and a half ago, and just began to, get into a little tips here and there, as we all have had some kind of a run-ins with some type of litigation, be it civil or criminal, or even in the federal courts. I can tell you that what I've learned in this last 18 months have been astonishing to the corruption of what is going on in the court system. And what I have found out is that those of you who are new to this or new to litigation or have some type of a debt collector or somebody coming after you in any kind of way, I believe that the first thing you have to understand is that civil and criminal are basically the same as far as procedure. The only thing that changes in litigation or any type of motions that you guys are filing is just the statutes and the rules and code. Everything else, as far as how you go before a judge and how the court process goes from the initial complaint all the way through a trial proceeding, is pretty much the same. What I'm finding is that you don't have to be an astute student in law to get some type of relief or justice. I believe that, what the attorneys have over the pro se litigants, because I will tell you that anytime you're going into a litigation and you're going in to file something into a court, the courts hate you. Now, the second thing I would say is that, under the federal Constitution, we are supposed to have certain unalienable rights. But what I found is, and what a lot of us in our group have found, and Randy will probably nail this and says this over and over and over, it's not about what you know, it's about what you can get on the record and what you can prove. If you tell, a person, let's for instance say an assault and battery charge, if you come into a courtroom and you are the person claiming the injury, and you're going after someone for an assault and battery where you was hit. It's not about what you say. It's not about what your witnesses say. It's what you can get on the record. And I'm sure that a lot of you have been into the ones that have had some type of a court litigation going on when you go into the courtroom, especially in misdemeanor cases and fractions. And otherwise, there are no court reporters. In California, they're trying to get rid of them all. We have actually a couple of court reporters that are in our group that are basically fighting the court system because they're trying to get rid of court reporters altogether. And what does that do? That puts us all at risk. We as people, we as American citizens are at risk. And if you think that's not a big deal, then you might want to get your head checked. Because if they get rid of the record, what do they have? We got a kangaroo court. I mean, when you go to court and you're, giving your situation and you're giving your stance and your position, and you're telling them that, there have been violations going on, there's fraud here, fraud there, I was attacked, this and that. What you say is blah, blah, blah. And what they do is the judges in the matter, they try to basically, and I know I'm jumping around a little bit because I'm trying to talk about different situations from the civil side, from the criminal side, and from the federal side. The judges in these matters try to woo you. They try to trick you. They'll tell you bold-faced lies. And I'll give you a couple of situations on how that takes place. And at this point, the pro se litigants, if you are a pro se litigant, which I believe that most of us on this call are, read the rules of your court. That's very important. Read the rules. If you are, playing basketball, and you go into, a different venue and they're playing football and you're trying to play basketball, there's going to be a problem, right? You got to read the rules. If the rules are that, you got to take, a ball from point A to point B, and you're sitting there trying to throw the football into a hoop, it doesn't work. But the judges won't tell you that. They won't tell you when you're doing something right, but they will tell you when you're doing something wrong. So as a pro se litigant, you really have to pay attention to what they're saying. You have to learn your objections, and you must read the rules of the court. Now, I know I'm going pretty fast here, but I'll give you a little situation on what has transpired with myself and my wife. That we were attacked at the airport, and over expired tags, and you would think that would just be a regular, ticket. You get a citation. In this matter, the cops took that from an expired tag situation into what do you want to call it? What's the word? An interrogation. They wanted to know.
Hold on, Melvin. Melvin, you got a lot of background noise. Are you on a bad line? Yeah.
Yeah. Hold on 1 second. Let me see if I can fix it here. Okay. How about that? A little better?
It's still there. It's pretty staticky.
How about now? Can you hear me now?
Yeah, it's not that we can't hear you. It's just a lot of clicking.
Oh, okay. Yeah, I'm up at the hills actually in San Diego, so it's kind of hard for me to talk. Let me see if I can step outside here and see if it gets better.
Oh, okay.
John, how's that? Is that better?
No.
No? Yes, I think it's where I'm at. I really apologize about that.
Do you want to hang up and dial back in?
Yeah, let me see if I can do that and see if that fixes it. Okay, I'll call you back in 1 second, all right?
Sounds good.
Okay.
Hey, Randy, it's Eric. Can you hear me?
Yeah, I can hear you.
How are you?
Good, but we got a bad connection. Just hold on here. If it wasn't him, maybe it's me. Everybody hold on just a moment. Hold on, everybody.
This is Melvin. Can you guys hear me okay now?
Yeah, we can hear you, Melvin. This is Eric. Randy just is checking something on her side of the connection.
Yeah, I'm thinking it's probably mine. I'm like way up in the mountains. So.
Hey, you remember me, right? We met at the Fred and Nina seminar last year in Orlando.
Yeah.
Okay,
yeah.
I think, Melvin, are you back on?
Yeah, I'm back on.
Okay, go for it. Go ahead and finish.
Okay, so basically I forgot kind of where I left off. I was talking about the situation with the...
You were talking about what happened at the airport?
Yeah, the airport police basically went from a expired tag, which is supposed to be a regular infraction, write a ticket, let that be that, into a full-on, hands-on situation to where they, I was choked and, the wife was actually pulled out of her vehicle without provocation and slammed on her face, on the concrete at the airport. So basically, what I've learned in this experience above the studying that I was doing already, I was about 5 or 6 months into, just studying the law, that, it's different. It's one thing to know the law, and it's another thing to be able to assert it in a courtroom atmosphere. What I found is that the opposing counsels, they really don't say too much, and it seems to me that when you do go to court, it's a fight between you and the judge, because the attorneys usually don't say much. They'll come in and present themselves and and say their name for the record, and they're appearing for whatever. But other than that, it's usually you and the judge going at it. I went through 11 hearings, basically going back and forth with judges. I recused one, or actually he had to recuse himself because I added him to the Title 42 lawsuit. And the other judges, basically, I was just running through them. I went through 6 judges. I went through 3 sets of prosecuting attorneys. They kept changing them on me. And what happens is kind of when you start to make ground and start to assert your position, and you're starting to do it correctly, people start to run away, especially when you're adding people to federal lawsuits. They don't like that too much. So if anybody has any questions on kind of like what my problem they might have right now as far as any type of situation with a civil case or a criminal case, I'll try to answer your questions the best I can. I'm more familiar with California law than I am with Florida or anywhere else. So if I do give you a statute, you might have to cross-reference it with something else. So that being said, like my first advice to you is to read the rules. My second advice is that I'm not giving you legal advice. I'm just giving you experience from what I've done. If you feel as though you need an attorney, you might want to call one. So if anybody I open up for questions. If anybody has any questions on any situation that they might have, I got about 10 minutes here. So.
Yeah, Melvin, this is Eric. I still talk to Mike in Atlanta, because he's the one that told me about you and all that. I'm glad, of course, I met you when I went to that seminar last year. But what's the status right now with your lawsuit? Because I had talked to Mike about it a few times a few months ago, but I haven't asked him anything about it in a while. So I just wanted to know where are you with all that, and are you making some headway in that damn thing?
Well, here's what you have to realize in a Title 42 lawsuit. And this is, some people, I've got a lot of bad flack for, because I tell people that, I dismiss my own case. And I'll tell you why. I went into this fight, I actually had 2 Title 42 lawsuits. I had 1 federal lawsuit against a credit card company for FDCPA violations, and I can get all into that, but that's another subject. And I had the criminal matter I was fighting all at the same time. Now, those of you who are in litigation right now, I'm sure you know that there's a lot of motions, a lot of paperwork that has to be filed. So with the federal lawsuit that I had against the police officers and 3 judges, I rescinded it and dismissed my own case. And this is why I did that. The first thing I did was when I filed my Title 42 lawsuit, even though myself and my wife had the same situation, I filed mine on my own in order to make the mistakes, whatever, if they came with the woodworks with some trick, I wanted to do it on myself before I went after them on my wife. Because basically my wife is very, an open and shut thing to me, but you got to understand what you're dealing with. You're dealing with judges who are in bed with everyone else. And I'm talking banks. I'm talking with the officers. Anybody that's on the other side, the judges are in bed with them.
Hey guys, go.
I got to a point in my litigation in the federal lawsuit on the Title 42. The first thing that happened was that the judges they get really irritated when you add them to the Title 42 lawsuit. So I had basically officers sitting outside my house for 3 days. We were followed, we were harassed, and all kind of weird stuff happens when you hit them like that. So what happened was that when I started to go into my 12B6 motions, they filed a 12B6 for failure to state a claim against me. I'm not sure if all of you guys are familiar with the 12B6, but that's what you're probably going to get when you file a 12B6. Is they're going to file that against you, saying that you're not saying anything. You have a failure to state a claim, which means that they admit everything that you're saying, but there's no legal theory or no legal cognizable way you can come back and nail them for it. That's basically what they're saying. Yeah, we did it, but they're failing to state a claim based upon it'll put all this raggedy case law. So the first thing you got to do is you got to shift through all the legal jargon and all the case law. Some of it was like incorrect. Some of it was just plain stupid. And me as a pro se litigant new at this, I thought I had to answer every little thing. That's trick number 1. When you file a complaint, your complaint must be construed as true. It must be construed liberally, right? It's substance over form. You'll get clerks in there that'll tell you, oh, you can't have this on here. These have to be numbered. This has to be this. It's got to be on legal paper, blah, 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 right? substance over form. As a pro per litigant, Haynes versus Kerner states that your stuff has to be construed liberally and construed to be true in your favor, right? And I'm just kind of giving you guys a roundabout explanation so that you can understand without me trying to, tell you, the entire definition of what a 12b6 is. So when they hit me with that, your first human response is, Eric, I'm just trying to answer your question and give you the story at the same time. When you try to answer, you don't want to fight their fight. Okay, it's like a boxing match. They come out with a flurry of punches. Yeah, you kind of like just got to sweep, move out of the way, and hit them with a counter punch. Well, what I did was try to throw as many punches as they threw. So every time they gave me some kind of stupid, response, I attacked it. If the magistrate came, they gave me some kind of an order, I attacked it. Every time they came back with, a reply, because once they do the 12b6, you have to do an opposition, right? So when I did my opposition, I fought too hard. I fought too hard for the wrong position, and they led me down a rabbit hole. Basically, they led me down the obstruction of justice road, which is basically saying that they were saying that I obstructed myself in between my wife and the police officers. And I fought that fight when I should have been just sticking to my argument, which was in my complaint, it stated that they had stopped for expired tax, which was the initial stop. Everything outside of that was outside the scope of their duty. Under the statute of the Penal Code in California, under 830.1, which is what an officer is, that they basically were outside their boundaries or outside their authority when they went into an investigation of a driver's license, asking for all this other stuff, and going into basically an interrogation. That's a violation of the Fourth Amendment. It's plain as day. But I went down and started fighting the legalities of the obstruction of justice. By the time I realized I fought down that road and went and attacked the judge and attacked everybody else, I was in a hole by myself going, uh-oh, I'm supposed to be over there arguing the facts of my complaint, and I'm over here arguing what they said or what they felt happened or what they felt I said. See, so when you go into a Title 42 lawsuit, it's got to be like a police report. It's got to be very dry. It don't have to be 10 pages. If you got a 10-page statement of facts, something is wrong, right? You write a police report, you go into a Title 42 and you write your complaint, it has to be very, very dry. They did this, they did that, they did this without provocation, they did that, I was arrested, put in jail, finished. But I went into dialogue. I went into narration, which is the human response. And by the time I realized that I was too far into it, I was too far away in order to save myself. If I would have taken this to trial, I would have lost. And then it would have hit me with $50,000 worth of attorney's fees, which I wasn't about to pay. So I'm smart enough to go, okay, well, I'm going to dismiss my case since I just filed me a bankruptcy and let them go after nothing. Try squeezing blood out of a turnip. So that's what I did. I saved my wife's case for now. Now it's time to file my wife's case. Because my wife's case will be a lot easier for me because now I know the rules. Now I'm familiar with the legalities of how to work through a 12b6, how to go for motion for summary judgment. I can fight anything that the magistrate might say. I know how to appeal, right? And so that's really what happened with my Title 42. I basically had to back away from it because I fought the wrong fight. So does that answer your question?
Yes, thanks.
Any other questions anybody has for me before my wife come out here and grab me?
Anything going on with court proceedings and anything traffic that you want to interject?
Yeah, my foreclosure issue, I have a foreclosure issue that I'm going through right now, and I tried to take my attack to state court based upon when I went to federal court. Bankruptcy issues are really touchy. So depending on if you file a bankruptcy Chapter 7 or Chapter 11 or Chapter 13, they try to stick by strict guidelines. But what they do is they cheat. And that's why I keep saying that, there's a lot of corruption going on in the courts where they're not trying to help the pro se litigant. They're not trying to help you. They're trying to help the banks and opposing counsel. So I just had a hearing on yesterday, and I'm going to send that to you right now. I totally forgot to do that this morning. Where I had a hearing in court with the judge, and the judge was basically reading off of a script, like he was reading, like he was a play or something. And he didn't want to get off point. He didn't want to get off of the real issue. And I will give you this, and then I'll be done with it. anytime you have a foreclosure and you've gotten some kind of, a securitization analysis, which is what, where I got mine from was Joe Esquivel, who is a master at it. Once you get an analysis, I don't care where you get it from, once you find there's multiple parties that are claiming a right to enforce, you have a hard-nosed case. So I want everyone on this call to basically look up under the UCC 203, D as in David. Okay? What that states is that if a transferee purports to transfer less than the entire instrument, negotiation does not take place. Transferee obtains no rights. They only obtain the rights of a partial assignee. Now, what am I saying? What I'm saying is that if there are more than one person on your loan claiming that they can foreclose, take your house, do whatever they want, just come in and do a trustee deed upon sale, change the grant deed and all this other crap, that basically they are in la-la land, and they're doing things that it's like a deck move almost, It's like getting carjacked. Okay, if there's multiple parties and they admit it, and you get them to admit it, then you have a strong case. And I did this in court. I got them to agree there are multiple parties. And what I did was I tried to lead them into a corner. So once I got them, the opposing counsel and the judge, in his opinion, to agree that there are multiple parties claiming the interest or on the right to enforce the foreclose. In California, they try to do it under 2924K of the California Civil Code. But how do you get that right to enforce? You get it under Article 3. Article 3 of the California Commercial Code, and I'll say on the federal side, under the UCC 203D as in David, what I just read to you, they have no rights. So if you got 2 or 3 people saying, hey, we have a right to foreclose, hey, I'm an agent for this servicer, oh, I'm the subserver for that servicer. Okay, you got 3 or 4 people claiming an interest, not even counting Freddie Mac, Fannie Mae, Ginnie Mae, Sally Mae, or whoever else is on your securitization analysis. That shows that, hey, you got multiple parties claiming an interest on this property that claim a right to enforce a foreclosure. Okay? Once I got them to admit that, all hell broke loose because they didn't know where I was going. So as soon as they admitted that there was multiple parties, I said, okay, well, great, let's go to statute. I'm the California Commercial Code 3203D, and I read it. Okay? Once I got that on the record, he started talking about, we're not trying to litigate this, or we're not litigating this case. I said, well, I'm not litigating either. I'm just making a statement, and I'm reading the law. This is what it states. They're in court trying to lift my preliminary injunction because I filed a complaint against all the parties, MERS, the lender, and 2 other parties. Now that we've done that, let's go to statute. Okay? They were trying to lift my TRO, my temporary restraining order. So I got them to agree that there were multiple parties, and once I did that, the judge was talking about he don't want to litigate. He raised his voice and all this other crap, and basically, when you're in court like that, it's kind of unnerving if you've never been into a court situation. You got a judge raising his voice at you. You think you're in trouble, right? But what I found is once you read the judicial canons, especially I think in California it's 3 and 4, where, the judge has to be gentle, they have to be kind, they have to know the law, they can't use rude gestures, they can't attack you, they can't point their finger at you, they can't lean up on you and mad dog you, and if they do, you make sure you put it on the record. Anytime something like that happens, you make reference of it. Hey, on it for the record, let it be known for the record that the judge is red in the face, he's frowning, and he's yelling at me. Did I do something to offend you? For the record. See, once you have that record, you can find that the judge has erred and that he's, being prejudiced towards the parties, and you get him in appeals. So that's what I did, and that was on yesterday. So that's about all the time I got.
Let me ask you a quick question before you slide off this phone. Since you're the one that just mentioned the California UCC, have you ever thought about hitting them with the proper instrument under California Commercial Code 3104? Because the reason I'm saying that is this. People say that they're a creditor or debtor all day long, but as you know, the gist of the whole court thing is they're claiming that a debt was not paid, and even though you and I already know the shit's already been paid many times over, to come to harmony with thy brother in the quickest fashion, to me, what I would strongly consider is tendering a proper negotiable instrument under the California Commercial Code 3104, along with other laws in the U.S. Code and the Code of Federal Regulations and even through treaty law, and tendering that to the court. Here's why I'm saying this. All the shit I'm talking about, I did the same thing for a dude here, and I stopped his house from being sold. We tendered an instrument payable to the clerk, this was based off of a judgment they had on them. When Randy introduced us, the whole case had already been adjudicated, so they had a judgment. So we just basically hit the courts with an instrument, with the instrument made payable to the clerk. We attached IRS forms to that, registered everything on the UCC with the state and with the county, and it stopped the sale. And I know the reason why a lot of that worked is because, you know, they saw them IRS forms, and they know that if they get out of line, that I'll stick the IRS on them for, tax evasion and all that type of stuff. So I'm just asking more or less like in a rhetorical fashion, do you think about this later? But I think you should consider that strongly because, again, if you pay them something, and you and I know that there's no lawful money, so then you can do a proper instrument, and it can be monetized by them because the court themselves, as you know, are a bank. That, to me, could be the quickest and easiest way to get up out of your case because, again, that's their whole case is that you didn't pay the thing. So if you argue, then you're creating a controversy. But if you do something to bring harmony with your neighbor, with thy brother, that's the real creditor status right there.
Yeah, that's pretty interesting. It's funny that you say that because I did tender them that an instrument, but I didn't bring that up. But I haven't attacked them in that manner or that fashion because what I wanted to do was basically at this point just get them to agree so that I have it making a record of them stating that there's multiple parties, and then I can pull them apart, the onion skin by onion skin, one layer at a time. Even under the Article 9 where, they're talking about a lien. In my case, they are talking about, he didn't pay his debt, he's in default, this and that. Well, in order to require or have a right or a title to enforce or to even record something in the recorder's office, they have to be the sole party, okay? So in my case, that the person that they're talking about is the holder, which is somebody that's holding something that's basically yours. Anytime you do a doc and you do a loan and you sign those doc papers, the promissory note and deed of trust is your personal property. Now, why do I say that? Because most people don't say that. Nobody goes in there and says, hey, that's my property. Whenever you pay off this so-called transaction, they're supposed to give you your promissory note back, right? So what does that make it? Your personal property. Now, that's covered under the California Commercial Code Article 9. That's a whole different ball of wax that I didn't even get to. The judge was so, adamant on me not addressing it that he only read what I gave him as the exhibit. I gave him the definition of the law under the 3203. He only wanted to read half of it, right? And then he said, it's something or another. What the heck that means, something or other. Just read it. So I ended up having to read it on the record so that I could make the record in order to go back and get him on appeals. Because at this point, what they were trying to do was raise the TRO, get the preliminary injunction lifted so that they could sell my house yesterday on my birthday. And I don't know if it happened because I can't find any record of anything happening. But he did that, and he knew what he was doing. And he said, well, if you don't agree with my rulings, then, you can take it to appeals. I said, I am going to take it to appeals. But what I would like to know is what facts and law you're using to deny the motion or to lift the preliminary injunction based upon you knowing that I'm going to suffer irreparable harm. Right? So I'm making a record. He didn't want to address it. So that's kind of where I'm at with that. And I want to get, Randy, you make sure you forward me his number. I want to, kind of do some research on that. The statute that you just gave me, but just based upon the basics of what I gave them in that courtroom, the attorney didn't want to touch it, the judge didn't want to elaborate on it, and he was just trying to say, well, I won't be questioned, is what he said, and I've made my ruling. And that's what makes these courts corrupt, and that's what makes it so difficult for people to get any justice because, the judges, they'll go out on a limb and do something unlawful and expect you figure it out, you put it on the record, and you take me to appeals.
Yeah, that's true, but keep in mind that what I'm talking about is a completely different avenue, and, they're not used to seeing this shit. They're used to people arguing on so many different levels, which is what they're used to wanting to fight. What I'm talking about is a solution that you can provide, and I'm not talking about an EFT because that shit will not stand up. You can do another kind of proper instrument sanctioned through various laws, including the U.S. Code, CFR, treaty law through the United Nations Convention on the International Bills of Exchange and International Promissory Notes, and that's a completely different argument. That's a completely different path. It's with the aid or the intent of arriving at the same result, which is settlement and closure of the matter. That should be your only desire. If you're tight like that, you can argue on some procedural shit and get out of it, but a lot of us ain't tight like that. I think it'll be better for you to take the path of least resistance, because that's what creditors are supposed to do, not want to create controversy and argue a bunch of stuff all day long. But the whole purpose of the court is like a third-party debt collector, and you can get into all that. However, again, I've done these calls with Randy many times since July, and I've been talking about the same stuff over and over again. But just in your situation, I think that you should seriously consider that as an avenue, because if you tendered them a proper instrument, you can always put that shit into your case file later as evidence that you've paid the debt, and all of the alleged claims of the so-called plaintiff are now out the window because you have given them a proper instrument.
Right, and I totally understand where you're going with this. And my matter is a little bit, and like I said, this is not an adversarial, debate. I think you're absolutely correct in what you're saying. My thing is that are the lender and the servicer and the sub-servicer even entitled to payment? And they are not, and I proved it in a court of law in front of that judge, and I don't think he liked it very much. That tax issue is a very strong point also. They don't want to touch that either. They don't want to get into it with the IRS. So exactly. I was just basically trying to just peel back the first layer and say, okay, just agree that there's multiple parties, because that kind of kills them, and they're dead in the water as basically saying, well, I'm entitled to payment. Well, how are you entitled to payment if you're a partial assignee? You can't be. It says the transferee obtains no rights. He didn't want to touch that. So, at that point, my wife's calling me, so I got to get off this phone call. Please forward me your information, because I kind of want to talk to you a little bit about that, Eric. I hope you guys, got some information that you can use. If you have any questions, feel free to, you can contact me on clearlyestablishedlaw.com, or you can go through Randy's website, and Randy knows exactly how to get a hold of me. And that'll be that for me. Randy, you have anything else for me? I got to get off the phone.
Well, tell Amy we're jealous, because we'd love to have you for a few more hours. So. All right. Hey, okay, thank you so much for coming on, and it was a good conversation between you two.
Yeah,
go have a great night, and happy belated birthday.
Okay, thanks. All right, bless and respect.
All right, night. Hey, Garrett, did you want to talk? I know I saw a text from you. I threw that back at you, but I know you were talking with Melvin. Did you want to say anything about some of the cases you got going on?
Well, no, there's nothing really, the only thing that's new in my situation, and I'm saying this as I'm getting ready to go pick my wife up from work, so I'm not going to be able to be on here much longer, but I did get an instrument medallion guarantee for my mom earlier today. I told you before that she got another car last month, and I got the first bill and all that, so we're going to send them the instruments next week, after the state of Florida files the most recent UCC-related document that I overnighted them. So that's good. But the funny thing is that first bank I went to, they were tripping and wouldn't even do the shit, and I was pissed. I was so damn mad. But my higher self told me to try one more branch, and I did that, and they had no problem doing that damn thing. And the guy actually even made a comment about, how it was prepared and how professional it looked and all that. These people think that I'm getting this from, like, one guy at the bank asked me if I got an instrument from the IRS, and I said, why would they give me an instrument like this? Yeah, so that's the most recent thing, and that just happened earlier today. I got the thing, medallion for my mom's payoff on her new car, and I did pay off her other car 2 years ago, and it'll actually be 2 years in December when I did that. That was right after I did the thing on her house. So, I mean, nothing really else is going on right now. I mean, I haven't heard anything else on Victor's case. I told you the most recent stuff with that where, I was able to stop that foreclosure sale. I don't have any evidence yet in my P.O. box of a satisfaction of mortgage or anything like that, but I'm going to have to just keep checking his docket to make sure that they're not going to try any slick shit. Right. But of course, our whole position on that is that the debt's been paid and so forth and so on. And in this case, we made it payable to the clerk, so it should be hard for them to try to get out of that, because if they try, then of course I can report them to the IRS Criminal Investigation Division. Because all the supporting documentation, the UCCs, all that, all that's on record. So.
Oh, that's And Rothman's case, anything going on there?
No, I mean, just, y'all went over there most recently to just correct some stuff that they had misfiled into the case. I haven't, and, they did respond to the production of evidence, but a lot of their response was bullshit, but, that's to be expected. Again, Mike's position is completely different than others. I mean, remember in his thing is we already sent them an instrument prior to them filing a case. So his position, I mean, he could argue all that other stuff that Melvin was talking about because a lot of that applies to his thing. But at the same time, his argument's a lot different because, it's basically saying this debt's already been paid. Here's proof. And the plaintiff has actually acknowledged receipt of the instrument in Mike's case because they sent him a letter on Bank of America letterhead letting them know that they received it. So they can't never got it. Yeah.
Okay.
So anyway, all right, I have to go, but I just wanted to jump on for a few minutes to hear what Melvin was talking about because, I did meet him the same time I met you, Mike, and a bunch of other people at that seminar.
Okay, awesome.
Yeah. So if you want to either give me his information or give him mine, you have my email, so just email that.
Okay. All right, you got it. Thank you.
I'll talk to you later.
You got it. Have a super night.
All right, bye.
All right. Does anybody else want to bring up their case or give us any updates on what's going on? Dave, I see you're in there. And anybody else who wants to bring up their case? Go ahead, Gloria.
Randy. Yeah, this is kind of interesting scenario. Actually, I got a certified copy from SEC, and I put the evidence into the court case for PSA, pulling and servicing agreement, and prospectus basically stating that trust has to give appointment who is going to be the servicer and who is going to be the trustee. So bottom line, they never put any appointment, and the power of attorney, if a servicer actually brought another servicer, then there should be a power of attorney that giving the power to another servicer. So I don't see any of that stuff. So actually, I put the certified copy from SEC as an evidence, and I have actually the book comes from SEC, is ribboned with a gold seal on it, and it's very difficult to, you can't really open that apart. So I just copy certain section, and I only order one copy, which is my mistake. I should have got extra copy, but because I had a one copy, I have to hold on to it for the trial. So what I did is I copied those pages, and then I went to the notary and let her go through every page, and she certified it. So I put that into the court evidence.
Hey,
and,
Rand.
Hello?
Chris in Las Vegas, man. Can I chime on this a little bit?
Yeah.
So wait, I'm not done yet. So basically, I put that into the case.
I've got an answer for you already. That's what I was trying to say.
Go ahead, Gloria, but Chris has an answer for you, he said.
No, wait. I just started talking, okay? So basically, I put that into the case, and guess what our attorney did?
What did
they cannot take this amazing evidence. So he wrote a one piece of paper and said a one paragraph and said, this notice was not filed according to the court rule 2214, New York Civil Rule of Civil Procedure. So returned everything, and it says notice of rejection. Okay. So guess what I did?
What'd you do?
Turned the whole entire pleading into declaration. Now, I put it as a declaration, and I declare this, and I declare that, and signed by two, leading people, and put it into a case, okay? And I basically stated that now this is declaration, and the other party has to rebut every line by line. And declaration said, the defendant put this declaration on this day, and if defendant put this affidavit on this day, and bottom line, plaintiff never rebutted, and we are running on a common law, and we do not understand, the defendants do not understand these court rules. We are not an attorney. We never went to law school to master the court rules. And once the defendant do not understand the court rules, there cannot be a contract. And according to the Seventh Amendment Constitution, the people shall get a common law, and common law is for common to man, and we're running on the maxims of law, and bottom line is all based on Bible, and public officers guarantee that they are going to give a people a common law. So here is the declarations and affidavits that is given to the final a chance for the plaintiffs to rebut, and I'm giving 14 days. So now I put everything back to the court again, the same exhibit from SEC. Now I'm waiting for 14 days, and usually our attorney will answer immediately, and I haven't heard from him.
Oh, wow. Okay. He doesn't know what to say.
No, I don't know what to say because I think that's it. And then I said, here is the writ of a defendant in error, dismiss the case without prejudice. That's it. So without prejudice, so I can go back and clear, get the title. So I asked for the court dismiss the case without prejudice.
Great. Chris, did you want to weigh in on that now?
I suppose I could. It is one of the consideration that amongst the papers and documents that are signed at the initiation of a contract whereby you promise your signature as the creditor, not the debtor, because your autograph secures the banks to get the credit to issue you the alleged loan. Of course, there was never any money loan, no consideration, but there was also amongst those documents a form of power of attorney, whether it was a tacit operated, it was included in the language of the contract, or it was an actual limited or general power of attorney or durable power of attorney. There's or special power of attorney, which is what a limited power of attorney is. If you were one of the two original parties at the signing of the contract and there's no longer an original party left other than yourself, then you have the right to revoke, rescind, and to render null, void, nugatory, and moot any powers of attorney by canceling and notifying the former power of attorney holder, the court, and whatever institution you originally contracted with, and thereby dismissing them and not giving any of these as purported as beneficiary or assignees a power of attorney to make an appointment of a designated beneficiary and take them out of the picture, and it doesn't give them the power to act for any other entity coming against you in a foreclosure action other than perhaps the original contracting party's general counsel, who may have some interest, but any subsequent parties that would be representing any pretender lenders or third-party debt collectors masquerading as a party and using that power of attorney to claim some right to represent some entity within the former agreement, it puts them on notice they've been dismissed and they have no lawful right to appear, to bring any case, and lack subject matter jurisdiction to proceed to anywhere, anytime.
Does that help you, Gloria?
No, I do not understand. It's too complicated for me.
It's a simple
I want
form.
something simple. I want something simple that I could present to court, and the court will understand, and all those words that you said, if I say that to the court, they're like, what are you talking about?
You don't say it. You let your paper speak for you, and it's a simple little one-page form where you terminate the power of attorney. You have to name the individual or the entity that he represents, supposedly.
The court moves by the evidence, lawful evidence. And you have to do a declaration or affidavit. You have to support it with facts, case laws, something, evidence by law or material facts.
Well, I guess what I have to say has no meaning, so it's kind of stupid to have you say something like that, so I'll just keep quiet and let you do it your way.
So I believe I have to support with a case law or material facts, and anything I say is a hearsay, and whatever attorney say is a hearsay, unless the attorney puts some lawful evidence, and swear that this is a true, correct copy of the original. Otherwise, I don't buy it. So same thing, our attorney will do the same thing. If I don't put something that I swear that I have the original and I could testify in the trial and I could bring it in any hearing and I have it, then I will consider that as an evidence. And same thing, what the court goes by your sworn testimony and legitimate document that you could support it, okay? That's the bottom line.
Well,
and so
you would generally notarize any document that you're sending to anyone, have it subscribed and sworn under jurat, and then it becomes documentary testamentary evidence you could submit to court.
No, not really. Affidavit is not good enough. If you look at the court rules, it says a summary judgment. It says the party who's moving a summary judgment has to put in an affidavit with sworn testimony and support with the material facts. Okay, so you can't just say I swear blah blah blah, but then you don't support with the material facts. It doesn't have a legitimate.
I absolutely agree with your position there, but if you serve them with lawful notice with a copy of the cancellation of representation and you have that subscribed, served, and sworn, then you have documentary testamentary evidence that they have been served and noticed with the dissolving of their power of attorney, and that's how they're coming against you. That's where they get their legal position to represent somebody. If you cancel that, you're rendered it null and void. But I'm probably just rambling in ludicrous hearsay that has no substantiating law, fact, and evidence, in spite of the fact that I spent about 14 hours reading about that.
I try that too. I even record my affidavit and say I cancel because this is IAGN contract. This is only my signature, and therefore I can cancel any time. Blah, 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 blah. I record and I put a certified copy. I did everything. But you know what? The true evidence that they really consider is something like this, where SEC, a certified copy, a government officers are certifying that these are true, correct copy of a pooling and servicing agreement. Okay, and something like that is incredible evidence. They just can't ignore that. So I'd rather work with something that the court will buy. Court usually don't buy. The promissory note is just one-side pledge and it's a IAGN contract, and I'm going to cancel that. It just doesn't work. It's rather they accept something like this. I never got money lended by a bank because I don't see any lawful document that the bank showing that I got the loan. Okay, I don't see any evidence in this court proceeding that the other party put evidence. So if the other party is saying, okay, we gave you the loan, then show me the evidence. okay? Show me the accounting record. The money came into my account, all right? And show me how the money came in, and things like that. So either party has to put something incredible evidence, and whoever put incredible evidence wins. That's it. So our attorney could say, my banking manager said affidavit, and she said she has all the banking records, and she said she has copy of, she owns the promissory note, and then guess what? They don't do affirmation by notary, but they said, I swear on the penalty and perjury, on the Title 28, Section 1746, and this is a sworn testimony under, a penalty and perjury. And then they don't put a notary in front of a notary sworn affidavit. Guess what? That's just hearsay. All right. So it's very, very important because Fourth Amendment Constitution said if anyone who has intention to seize the property, they have to put an oath or affirmation by the notary. Okay. So you got to pay attention to those little details, how they came in with a complaint, and see the affidavit, whether affidavit is executed correctly. And then if she says, I have the promissory note, now you can challenge it. Okay, bring that into the hearing, please. So here I filed a writ of cross pay, and such date, all the parties should appear and bring the original promissory note. Guess what? They're going to cancel their writ of a hearing, because they don't have a promissory note. So that's how you move, So if they are swearing that they have a promissory note, make sure you attack them and say, hey, I want to see that, So you got to attack whatever they swear, but they don't put any particular, instrument. And in this case, also another case that I was looking at this document, she swear that I'm a banking manager and we own the note. We gave her money. We lend the money to the defendant. Okay. Then she never swear all those the material facts that like a power of attorney, a limited power of attorney, and all kinds of stuff that was put in. She never swore any of those documents that I am the one that I put this document in here. So I basically told the court all these material facts that they put in, she never swore that this document is come from her. It was our attorney put it in there. I said, that's not acceptable. She has to sworn every the material facts that she put in, that these are my document in my hand, and I put it in as a material facts. So
there is a case, if everybody wants to look it up. My friend Tom Chapman, he's been our guest in the past, and he sent this to me. The case is Cosajay, 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 and I may be saying that wrong, versus MERS, MERS. And if you want to look it up and read the full story, I'm going to only read part of it. The title is A Watershed Moment in Foreclosure Battle. Judge McConnell hailed as savior to thousands of downtrodden owners. And I'm going to skip the first part, but highlighted, it says, Judge McConnell's decision in this case puts to bed once and for all the contention that homeowners have no right to challenge fraudulent assignments appearing in their chain of title. And in page 11 of that decision, he wrote, the court denies defendant's motion to dismiss and finds that Ms. Cosajay has standing to bring this lawsuit against defendants. The court finds that Rhode Island law provides that same dual ideas basis for deviating from the general contract rule. Therefore, the court finds that Rhode Island law provides that same protection to mortgagors in the same situations in which the First Circuit found the Culhane and Woods plaintiffs under Massachusetts law. And I'm going to read just a couple other bullet points, but you got to go look it up to get the whole thing. It says this ruling will impact not only every foreclosure case in Rhode Island Supreme Court, but also every foreclosure case across the country. By far, this is the biggest decision concerning home foreclosure by a judge in the country in recent years, and that came from an attorney. And then also, this ruling by McConnell will bring a new perspective to every home foreclosure case ruling thus far and reinvigorates homeowners' resolve to continue fighting the bank and mortgage servicers. As a result of the visionary decision by Judge McConnell, which I wouldn't necessarily say it's visionary, today is a new day in home foreclosure law. And again, the case, Posa J. versus MERS, USDCT, Rhode Island. And there's a lot more to that story. So page 11 is important. And again, watershed moment in foreclosure battle. And the judge is Judge McConnell, so anybody can go look up that case. And thank you, Tom, if you're on the call, for sending that over to us. I wanted to give, if I could, Patrick, if you wanted to take a few minutes and just give us an update on what's going on in the per tandem, the functions on gene activity. He's going to talk briefly, and then I know Dave's going to talk for about 5 minutes on his case and what's going on. So, Patrick, if you're unmuted.
Yes, I am. Am I here?
You are.
Okay. Thank you, Randy. Just briefly, I want to talk a little bit about therapeutic potential of what's called the NRF2 activator. The people that are involved with Protandim know what that is based on their experience with Life Vantage. But essentially, it's a protein that activates genetic expression, supports some pathways. It's a protein that supports pathways on gene modulation. And I'll read just briefly a first paragraph into a study, Oxidative Stress in Health and Disease, the Therapeutic Potential of NRF2 activation. It's in molecular aspects of medicine. And just briefly, it goes on for the past 4 years or so. Oxidative stress has been increasingly recognized as a contributing factor, basically in aging and various forms of pathophysiology associated with aging. In the view of the publishers of this paper, oxidative stress is largely centered on what's called superoxide-centric damage. And it's on the sources of oxygen-derived free radical damage in molecular havoc. So we're seeing, essentially what that's saying is that inside on the molecular level in the cells in our body, we're seeing oxidative stress set up aging. And it's associated with and focused, this paper is focused on antioxidant enzymes, especially superoxide dismutase, catalase, and glutathione peroxidase. And essentially what we're seeing with this paper is that the NRF2 activators as potential therapies for oxidative stress and inflammation and chemoprevention. Write those three terms down, oxidative stress, inflammation, and chemoprevention. In this study, the study identifies and clearly annotates very specific gene locations in atherosclerosis. We're seeing 19 genes that are improperly modulated in atherosclerosis. Historically,
improperly modulated means what?
Well, let's just say that you got a radio on and you get it fading in and out. That's modulation. So if we have a precise radio dial focus on a gene, we get a very specific function. And when those functions are disrupted, either overly impacting or in a smaller fashion, lower impact or expression, that's improper modulation. We want that gene to be functioning exactly as it's supposed to be, either on or off, or part way on or part way off, but it shouldn't be in the opposite direction of health. Okay? Now we see another one in colon cancer, and this is in a carcinoma. We see 28 genes that are improperly modulated, meaning they're expressing incorrectly. In Alzheimer's disease, we're seeing 66 genes. And what we're seeing with the addition of Protandim is that those genes, 19 in atherosclerosis, 28 in colon carcinoma or colon cancer, and in Alzheimer's, 66 genes, we're seeing that protandem, through the upregulation or the proper gene expression via the NRF2 pathway, those genes express properly. And the diseases then are properly taken care of by genetic expression. What a powerful and profound paper this is. And what I'd like to say is that whenever we're talking about protandem, we have to be very careful when we talk about health and wellness. If these papers are PubMed, peer-reviewed, published papers that we're talking from, we can say everything that's in those papers without fear of any retribution. So I want people to understand that this discussion tonight comes from a very solid source. It's Molecular Aspects of Medicine. And the title of the paper is Oxidative Stress in Health and Disease, talking strictly about the therapeutic potential of NRF2 activation. So this paper was published in 2011, Randy, and there's more work going on all the time. We're very fascinated. As you know, I study deeply inside of the literature and Dr. McCord's work, and there's several universities, about 28, I think it might be 32 medical schools now are studying protandem. So their papers are credible, they're valid, and this is just one of them that we want to bring forward to people tonight. So if they're looking for anything regarding, let me say it this way, over 200 diseases that are impacted or set up because of oxide peroxidation, lipid peroxidation, protandem can deal with them and support a proper return to health.
I was told that the Navy SEALs are using them, and I was also told that one of the football teams is using them. Is it Baltimore Ravens? They used it for the Super Bowl last year?
Yeah, very nice. We've got, let me just speak briefly to athletes. Protandem does not violate the anti-drugging, anti-doping laws for either the Olympics or professional or college and high school sports. So it's safe. There's no drug interaction and no drug problem that the BRC, I'm drawing a blank now on the agency that rates for drug addiction or drug presence in blood, but it does not violate that code for athletics.
Okay, good. And, you know, you said something on one of our calls, I don't know, I guess you probably talked about it a month ago on one of our calls, and you said something at the very end of the call. It was so profound. Something about this being one of, like, the main things of having in your diet. Is that
well,
like
what
one
I
of
would
the most
say
important things that you could ever put in your diet? I forget how you said it before.
Yeah, from my perspective, Randy, I would tell people that we no longer have the luxury of saying that we can maybe overlook protandem because of the food sources that we get today, and everybody's aware of antioxidants. I don't know too many people, especially when we talk, and we do quite a bit of talking to large groups. Without a question, without any doubt, everybody has heard about antioxidants. But what they don't know is that the antioxidants today, especially in supplements, are incapable of dealing with the oxidative stress, the load that we have today. Nothing in our diet can support what protandem does, and I'll say it this way. Antioxidant molecules do one free radical at a time and they're done. So one and done. What happens with protandem is you get one superoxide dismutase, one antioxidant free radical scavenger, hitting 1 million free radicals per second every day for 13 days before it's used up. So when we say that this is the most profound and most powerful supplement, that it should not be overlooked, it is basically a luxury that we no longer have. We cannot ignore this one today.
That's some pretty powerful words. Does anybody have any questions for Patrick? I know we teamed up with Protandem. If anybody wants it, all they need to do is just go to lifevantage.com www.facebook.com/42action, and you can get it there. You can just hit the join button, and from there you pick if you want to be a representative of their company or if you want to use the actual product. There's no pressure. It does help support what we're doing here if anybody wants them. I know it's in my diet every day now and has been for quite some time, and it's also in my kids' diet, so make sure that they get it. So, and occasionally I've thrown it to the pooches, although they do have a canine product. There is something for the dogs. And I've also just recently started using their skincare line, and I'm very big into the skin and staying youthful, so I'm definitely one person who will put it to the test. So thank you for that. And just briefly, you guys are doing stage 4 clinical trials, right? Stage 4 cancer patient clinical trials?
There's several studies underway right now, Randy, and I can't speak specifically to any individual studies, but I do know that more are being designed. More universities, medical schools are coming online. I also know that Dr. Gordon in Sioux Falls is looking at some heart studies as well. So there's always new studies being designed and more coming on board all the time.
Okay, awesome. Thank you.
Mm-hmm.
Always love you getting in there and sharing what you got. And if you ever have anything ever, the floor is always yours. You're always welcome to our calls. And for those of you that have never heard Patrick before, he's a doctor of naturopath. And I'm sure there's more in there. I probably don't do you justice. What else is your background, Patrick?
Well, when I went to school, I went in with the naturopathic background. And additionally, I was looking at a PhD in alternative cancer therapies in the natural realm. And that kind of got scuttled, so I didn't get to complete that. I was 5 years into it, never did get to complete it, but it was a real eye-opener, and Protanum fits right in there. By golly, I'll tell you, I can't say enough about how Protanum fits into that, and I wish I'd have known it when I studied originally and began to do the work, that Protanum was in the market, but I didn't discover that until 2011.
Okay.
We always appreciate being able to come on, Randy.
Oh, thank you. So glad to have you. Thank you. Okay, so we're going to move. Dave, if you're in there, and I sent you off a message, I just wanted to have you give your website again, give everybody the brief updates of what's going on with your case. Dave in Colorado.
Hi, Randy. Hello, everyone.
Hey.
Good evening.
Good evening.
There's not a lot more going on yet at this point, but I'm just moving forward in knowledge and understanding and education and with the help of y'all. What I wanted it to do is, I read something that was very profound on Veterans Day. And Randy, I believe I sent it to you pertaining to my son's posting on Facebook. Am I correct?
You did.
And did you? Now I'm working on putting those words together in a proper format. But I just want to read the paragraph. My son, who has been in the service for 18 years, he's in the Army, and he's a lifer. He's got a career as a professional. And this is what he has to say for all veterans out there on Veterans Day, which I read, and it was very kind of what he said to pay tribute, but it was also very hurting in the same breath when these soldiers of past, current, and future are protecting our liberties at home, and the corporate thieves at home are stealing the liberties that they're out there fighting for. So this is what my son had to say on Veterans Day.
Okay.
Happy Veterans Day to all my fellow active duty members, retirees, those that served time, those that paid the ultimate sacrifice, and all their families. It's been 18 years that I've served on active duty, and I'm proud of it. I get up every morning motivated and ready to lead my soldiers. I strive to be the best leader the Army has to offer, and I wear the heart of those that passed while in harm's way on my sleeve every day. Thank you for keeping me on my game day in and day out. You will not be forgotten. For those currently abroad, keep your spirits up, your head down, be safe, and call your families when you get a chance. Much love. Signed by my son. When I read that, it kind of tore a hole in my heart for all the criminal activity that this state of Colorado has all been part of in my life by taking every liberty that I've ever had when I'm supposed to go to them to report crimes when crimes occur. And it's such a quagmire that's gone on, and many of you know my story, and I'm not going to go into it. I'm working on putting some information up on a website. I'm going to start getting my information out on Twitter, LinkedIn, social media. It's going to get out there to the right people where somebody's going to want to come in and say, hey, what's going on here, state of Colorado? What's going on here, FBI? What's going on here, authorities of civil officers who's to protect citizens' rights? What's going on here? Somebody's going to come in and step to the plate to start questioning the same authorities that I've been going to. And they're going to have to answer to someone somewhere. So my website it's a constitutional website, and it's a constitutionalclub.ning.com /groups/Colorado -fraud -forgery -corruption. If anybody wants to see some actual exhibits of what's been presented of fraud on a court, of forging government seals, of several criminal acts under Title 18, and it's all been reported, and it's all on record, and no one does anything about it, somebody has to corral these crooks, these criminals, and put them where they belong. So I'm working on adding some words to what my son had to say, and I'm going to get it out there. I will get it up. I will be posting on Randy's Title 42 Twitter page and the different places she's at. So you folks will be able to see some of the actual exhibits, proven fraud, proven crimes. You actually be able to see them, say, what's going on here? Randy's seen all the exhibits. Some of you others have also. So I'm just trying to get my game plan together on, I like what Melvin said, is put it on record. So that's the process I got to go through, and I was hoping that somebody was going to be around to get back to me to start giving me some ideas on processes. Hasn't done that yet. So I'm still moving forward and having hope that I'm able to, bring this thing to fruition where these criminals are going to have to be brought to justice.
I got a story just to add in there. A friend of mine that I went to school with, her son, Patrick Pearsall, I know you read this, her son's very health conscious. I'm just going to read it. It says, my son is very healthy or health conscious and reads labels before he eats and drinks. A neighbor had a big tub of those bright Kool-Aid bottles and offered him one. He whispered to the mother, my friend, Mom, I don't think I should drink the Kool-Aid. And she was cracking up when she said it because, of course, to adults that means it has more than just the meaning of the drink. And, it's a good example. Don't drink the Kool-Aid. Dave has an incredible case, fraud committed right from the start. I did see Andy again today, and he was really busy, just so you know, Dave. And I said, did you get some of Dave's latest emails? And he said, yes. And I'll tell you this, you've done so much research and sent so much good stuff, and he's printing off everything, that he did make the comment that you've sent so much stuff that it could take the rest of his life just to work on your case alone. So we did get a good laugh out of that. I know that doesn't help make anything happen, but he did tell me that he's still printing it all off. He does still plan on calling you, so we'll see.
Here's my comment on that.
Yeah, you don't even need to say it, but let me tell you this. I did ask him if he wanted to be on one of our future calls. You might be able to corner him then. So I would hold out. So we get him cornered.
Here's a comment I want to say. Nothing against Andy or nothing like that. I have such a strong, compelling case.
You have an incredible case.
If the right mindset, legal mindset, was to take a look at my proven evidence that's on record and went through the details that I put together as fact, they could work on there's one case they could work on, and they could retire the rest of their life.
Right.
Why don't you contact me, because actually I will be involved with the grand jury, and I am actually becoming a private attorney general, and also we are working with the Pentagon and some good Jesuit, and I think maybe this case can be presented.
That would be awesome.
Great. That would be outstanding, yes.
Randy has all my information. I mean, she can put you in contact with me. Randy can send me your information. I can put you on my mailing list of things I've been continually forwarding.
So you may want to get involved in becoming either grand jury or private attorney general. You could actually prosecute this crime. And another idea is you could actually bring the United States of America as a co-plaintiff and sue them.
Yeah, this is huge, totally huge. When it ties into my wife who has MS, when it ties into what they did against her to attack me under spousal discrimination, to force me into a court that ends up being a fraud that I uncovered, and it just the domino effect is incredible. That's all I can say.
Yeah, right now the government wants to clean up these criminals right now, so keep in touch with me. Okay.
They just need to look in every courtroom and they'll find the bulk of them right there.
Say that again.
There is also next week we have coming on a guest who's going to talk about a location. I don't know exactly where, but there is several guys that are bringing to justice a case against over 20 judges, and apparently the case looks pretty good. So he's going to tell us about that next week. That's Brad out in Maricopa County, a good friend of mine. Patrick, you may know him. In my Republic days, I became very close to Brad, and we were on the Armed Services Committee together. So really just an incredible caliber of person. And I won't say who unless he wants to say it, but we know somebody, and I'll just leave it at that the bond that we have when we're born, this particular person that we know, and again, I'll leave it up to him if he wants to say it or not, someone with huge credibility, used it to pay their taxes and some different bills, and it worked perfectly. So we don't get too many people that come on here and talk about that. In fact, I don't think we've ever had a guest ever talk about that. And I don't know if he will talk about that, but it's pretty fascinating that it did actually work, and there was no questions asked. Nobody ever came back at him for it. So,
if you'll let me add a little bit to your contributions, Randy.
Yes, sir.
One of the things I was reading was the securities instruments section of the United States Code, and in the very first few pages of that, there's always a lot of great information there, whether it's the rules of evidence or whatever else, when you're dealing with the statutes at large and the rules of the government. And in that particular one on the security instruments, it says that CD and Company is the same or analogous to the Depository Trust Corporation, which I happen to know is a subsidiary of the Depository Thrift Credit Corporation, also the National Security Credit Corporation, the Mutual Security Corporation, the Government Securities Exchange Corporation, and these are all these large pools of money for the bankers and the governments to deposit the monies they've stolen from the people. And many times the judges have fiduciary investments. In fact, their pension funds are vested in the banks that write these mortgage security agreements where they hear the cases that can perform even in the district courts and the federal court systems. So they're conflicted, and they should sua sponte, on their own motion, remove themselves from the case in the courts if they actually have a vested interest by the retirement funds that have investments into these funds that are set up by the CAFR committees and the other agencies of government and these secret offshore and global banking accounts. Additionally, word of note that some might be curious, we met with Tom Benson at his home last week. He's out finally. He was coerced to make a plea agreement to a lesser charge as opposed to having a bunch of them even more so layered upon him. Kelby Smith was there and spoke a little bit, and he suggested that one of the trusts that they had is called the Ungodly Trust Trust. Rather curious that some of us, we might, some of the indications are that you may have to actually petition to the Secretary of the Treasury in Puerto Rico as opposed to the one in the District of Criminals to do some of these claims against your birth bond and retrieve your funds, and perhaps some of the set-offs or adjustments to your credit and so on and so forth, and mortgages if you're trying to do them. And the one in Puerto Rico actually is the higher position in the government, being the Federal Reserve and, of course, the IMF, or where all the monies are deposited. Also, Tom Collins had become incarcerated and is out again. And then we're going here in Las Vegas to another one likely on Monday for Ron Lesnick again, habitual victim to the corporate gods that run all these scams to steal people's money. So that's an update on that. Also just got back from sitting on what's termed a team meeting, and I perceive it's actually a HIT team meeting with the Child Protective Services and their groups. And I got to sit in as a Child Protective Services Advocate Counsel privately for the people that I'm helping there, and was able to make some interesting points on the record. One particular that was worthy of mention, perhaps, is the dangers of administering multiple psychotropic medications to a child under the age of 10 or even under the age of 12, for that matter, which effectually creates what's termed a chemical lobotomy to erase the memory, and it's a form of evidence tampering to erase the memories of the child to be able to testify to the actual truth, facts, and law of the egregious, horrendous sexual violations that occurred to he and his sister and some other siblings, not from the family, but from others outside the family. And since the state is anxious because they've licensed these schools where these children were taken from, they are culpable and liable for failing to be diligent in maintaining and protecting the children and the parents from being preyed upon under those states' licensure schemes. So they have also accepted a certain degree of liability and culpability for their lack of action and protection that they extort the taxes from the people to provide for, as well as the licensure fees for issuing the licensure and supposedly oversight for the particular agencies of the schools under their 501c3 and other state provisos for operating their state-sponsored schools. And even if they are private schools, they still have to have state licensures. So it's growing up to be a very, very interesting scenario in Salt Lake City.
Hey, I did hear you spoke with a mutual friend of ours over the weekend or sometime this week. Kelby was out there, and I don't know if you're aware of it, but he did go home with food poisoning. Las Vegas did not. He went home with food poisoning. He's been sick probably all the way up until today.
So he stayed a little longer than what he anticipated.
Well, he did go home, and it hit him hard there. So Las Vegas did not treat him well. But,
well, I do know that Kelby is coming up with a really incredible contact to provide securitization audits with a top accounting firm, and he's also got Michael Pine, which is a disbarred because he was being honorable. And actually, this is a tactic that the federal government is using quite frequently in the states, where the attorneys are actually beating the state and the federal agents in courts. They use disbarment as a means to try to take them out of the action because they're too difficult an adversary to deal with in the courts. So they can't beat them. They try to terminate their license. And, in fact, that's one of the tactics that I'm seeing repetitively played over and over by the Utah state, where they go out and threaten to pull the license of purported professional medical care and mental care individuals who have licenses under the state. And if they're saying something good for the parents in this case and aiding their case, they go out and threaten them with licensure revocation to coerce them to come around to say a story that's favorable to the state's position, and therefore are actually obstructing justice, denying due process, and using terroristic oppressive threats under color of law to try to pro se execute their political agendas of claiming responsibility to parents who actually had no responsibility whatsoever. And there's another law I just learned about last night, and I don't have the number in my head. I apologize. Maybe I'll have it next time we speak. That has to do with the failing to due diligently invest. In fact, it might have been on Fred Nina's call. No, it couldn't have been Fred Nina's. It was a different one. I'm failing to diligently investigate, and that's what the state attorney general there in this case, the state attorney general, has done. She has failed to honor, and it was the professional code, and it might have been Article 3 in the professional code, I think I remember, and it was a different state they were in, so it was the state rule was 300 something. And it had to do with not doing due diligent investigation in a case to determine the actual facts and taking the least laborious task form of investigation and assuming facts based upon the first evidence that came in without doing any further investigative processes to determine whether the facts that they had been suggested or determined were accurate, or if there were other facts that had been suggested that may just have been as likely accurate as the ones they had used a paradigmatic numerical model to hypothetically use to basically count their case on. There's a factual circumstance that in a high percentage of the Child Protective Services family abuse cases, there are family members, either close or extended family members, frequently involved in the abuse cases that come under their purvey. But in this particular case, it is not the case specifically, and there are others outside the family connected to the purportedly Christian private school that they attended, which was a full inclusion school of all grades from kindergarten through high school. And so it provided a special opportunity without the school doing due diligence to protect the children while they were there, and allowed unauthorized individuals to remove the children during the school hours and return them and let them be abused and not do anything except to try to mask the crime by claiming the children's panties had been soiled at school, laundering them and returning to the children a day or two later and say they found them and they took them home to wash them to get rid of evidence. So it's very complex and it's a very, very intricate thing, but I'm paying very close attention, and hopefully it'll uncover things that may help everyone that's fighting against Child Protective Services, which is actually the same thing that all those states and prosecutorial schemes are doing, is they fabricate these fictitious stories, adopt the law of rhetoric, which states that one must lie in order to speak the truth, which is a abominational lie itself, and it's not bounded by any substance or law, morals, or ethics whatsoever. In fact, it's devoid of all those things. But whenever they make up these discoloring stories to try to claim guilt on someone, and they don't have the first-hand knowledge of competency to testify as a witness, of course, it's all hearsay, as I guess it was Gloria before was saying. If they don't have first-party competent knowledge, then what they're testifying to is hearsay, and it has no point being accepted on the record of the court, but you must object to its entry and cite the objection and cite the hearsay rule as an opposition to it. But that's probably enough for me tonight, and thank you for letting me contribute.
Well, don't hop off. We have Brian, who's going to be hopping on here in just a moment. He's in the Chicago area, and he's been working quite a bit with the militias. He's in, let's see, code. He's asking me for the code. Hang tight, you guys. Okay, he's going to be hopping on our call here in a second. He's going to give us a quick update on what's going on with the militias. Because they are the backbone of our country, and if things go awry, they're the ones that we're going to be counting on. So give him a second to jump in. Go ahead, Chris.
Well, I do know quite a bit about John Durash's. I've read his case that they're bringing against the judges there in New York. I understand that there's some that are also taking place in Illinois, maybe Florida, and I don't know where else it's taking place, but it's good to see some of these common law grand juries perhaps getting some legs. Now, whether or not they have any enforcement has yet to be determined, but the pro se executioner is supposed to take that out. So I'll keep quiet unless somebody else. I hear a little bit of talk here in the background. Maybe wants to talk.
He said he'll be on in about 4 or 5 minutes. He'll be popping on. Does anybody want to bring up their case or anything before Brian gets on with us? Been quiet. By the way, Chris, thank you for always being a warrior for kids. All this CPS stuff and always updating us. I know we appreciate it. And if there's anything, I know that there's certain case law, ROSCA versus something, but if you've made a bigger compiling of some things that have to deal with somebody fighting for CPS, I do get those questions a lot, or fighting CPS, not fighting for them. Send me anything that you have, if you have it, like in a zip file or whatever, and I'll send it out to them happily.
I pretty much copy you everything that I find is worthwhile, but I cover different areas of law, as you well know, everything from foreclosures to child protective to criminal law to traffic and all that other stuff. So I delve into a lot of different areas, and fortunately I'm able to recall a lot of different things. I've been given gifts, so it's something that I just do. I don't know if it's possible or not, but I do it because I'm supposed to do it, and I try to help people as much as I can, but I can't do their paperwork for them. I can try to relate circumstances, facts, and law and evidence to them, but I can't force them to do anything, and if they don't take what I share with them, this is something that's really, really important, Randy, for anybody on the call. When you're sending someone your documents and you want them to look at your case, if you can either one at the first of it, put out a little printed guideline of the order they're in, and they should be in an order that reflects either a reverse chronological order or which is really putting the most current document to the front end, followed back to the very first document at the end of the thing. There could be a case where it might be beneficial to have the first document, since we're all supposed to start at the very initiating foundational event that started the events of what we're trying to fight against, because usually that reveals the defects in the sufficiency of service of process, or the way they carried out the stop, the lack of foundation to have a lawful stop, or to have done anything that occurred after the stop, so everything that occurs after the fact is null and void ab initio if they didn't do it right in the very first place. If they didn't have the warrant to come in, they didn't have suspicion of probable cause of commission of a felony crime. And this is where the attorneys deceive the law enforcement officers when they train them, educate them wrongly, so that they will be under a misguided appreciation of what the law actually is. And it tells you that probable cause of the facts or circumstances which would cause a reasonable man to believe that, one, a crime has been committed, and that's a felony crime. They don't tell you that. And two, that the person accused committed the crime. Those are the facts that amount to probable cause to suspect that, one, a crime has occurred and the person accused committed the crime. It has to be a felony. It can't be a mere misdemeanor. That's not probable cause. And so that's one of the tricks these legal mercenaries play on the people to try as a ruse to confuse and to try to mislead them to provide a pretense for generating revenue.
Thank you for that. Does anybody have any questions for Chris?
Is there anyone? Hello?
Yes, go ahead, Gloria.
Is there anyone knows how long it takes for the court to activate a traffic ticket? I had an invitation to United States District Court by the state trooper ticketing me, and I returned everything back to the court on October 21st. So it's about 23 days, and I haven't heard anything from them.
So usually they have 10 days to respond, 20 at the very max. So if you haven't heard, it's time to communicate again and want to know what the response is. They have an obligation to respond timely. Hey, Gloria.
So maybe the case has been dismissed?
Well, I wouldn't operate that presumption. I'd certainly check into it. You can go online to most any of the courts and search the databases of activated court cases. If you have either a citation number, you can search by name, you can search by the case number of the court if they have one, and sometimes
they
you
don't
can
have a case number. It was just the tickets, and I returned it, and the court told me there's no case number, there's no officer put any oath or nothing.
Well, it sounds very much like the case may have gone away, and that happens pretty frequently, but you have to verify that. You have the obligation of verifying that, and sometimes you can do it with a call to the clerk court or a personal appearance. The hazard of personal appearance is you're there in their playpen, and if they choose to lock you up while you're there because they haven't advised you and haven't given you diligent service of process and taken advantage of the situation of you appearing in their playroom to see what's going on, then you've hazarded yourself by volunteering to come down and put yourself in their jurisdiction. So it's better to either have someone check for you, give them a limited power of attorney to check in that nature on this particular matter and relating to this ticket or whatever else, if they have the power to speak. And
well, basically, I returned everything, and the clock stamped it for the receipt. So actually, I have evidence that I have sent everything back to the court, all the originals, refusal for cause. And the bottom line, they haven't answered me nothing. They are in default.
Well, I don't doubt that, but in their twisted world of thinking, they sometimes see things differently than what the law is because they have a hidden agenda of stealing money from you by any means possible, whether it's lie, cheat, steal, or make fictitious claims, and they're pretty expert at that. So all I can say is,
actually, they offer me a contract, so they said I am not going to be released unless I sign, the whatever they were typing. So I looked at it briefly. And the trooper said, "Do you understand? First to read everything." And I said, "I do not understand." And then I signed it under duress, threat, coercion. Authorized representative UCC 3-1-308. Authorized representative. And then I returned everything back to the court. And under duress and threat and coercion, actually there's no contract. So I think it's null and void. and I think they probably closed the case. And I actually sent a notice to the judge that if he doesn't dismiss this case, I'm going to sue him. So basically that was a notice to the judge. And I haven't heard anything from the judge, neither trooper. And I told the trooper I'll sue him, and he has to rebut my declaration.
If you will allow me, Gloria, I'm going to suggest that you might use a little different language. When you tell them you're going to sue them, they interpret that as you're making a legal threat. The proper or more correct way, I'll say it that way, to suggest that you're going to seek all possible legal remedies to ameliorate or correct the situation of their position of attacking your rights without any lawful right, title, or interest or contract. And when you refuse to contract, which of course you know is your right, then you've basically taken them out of the picture. But they're a twisted group of terrorists that you're dealing with, and they deal in the world of legalism, and everything is legal and nothing is illegal. So you have to be really careful when you're dealing with two-headed snakes. But if anybody can, you will.
But you know what? I have a right to do a administrative process in private and under form of a letter of interrogatory. And so I send a administrative notice and say, hey, if you don't drop this case, then you will be the party, in the sue. And then basically towards the bottom, I usually say this is not a threat, and I'm seeking for basically a settled case, and I'm not a combat. So I give that notice. So. It's up to them if they want to continue harass me, but so far, so good. I haven't heard anything from them.
Well, I have a lot of knowledge, Gloria, and I really applaud your cojones of fighting in this way. But I just caution people to be cautious how you phrase your intents to seek all legal remedies, or lawful remedies, I think is a more accurate statement. And as long as you operate within law, you're not an outlaw like they are, and they're using the outlaws in the situation. But I really applaud your tenacity and your adversarial nature.
I don't treat judges any different than anybody else. Okay, they're
well, we'd love to know what you got your invitation for, Gloria. If we could take a pause on this for just a moment, because Gloria, we want to hear it, but we're going to hold you off. Brian has joined us on the call, so I want to get him in because he is coming in on special appearance here for us. But Gloria, hold that thought, because everyone on this call definitely wants to know why you got an invitation. So, Brian, if you're on the call, if you would, tell everybody a little bit of background, what it is that you work on, and then tell us what the update is with the militias, what's going on around our country, Sheriff Mack, Oath Keepers, everything you're involved in.
Oh, I can do that. I'd probably answer the second question first. You asked me, how the militia is doing. I'd have to say, well, how are you guys doing?
How are you guys doing? That's right.
I mean, we the people are the militia. That's a Supreme Court decision.
That's right.
When you turned 18, you were already in. It's not really a gang you join or a group of desperados. You, in defense of yourself, are the militia. You guys just happen to be going a different route than some others. As far as, what I've noticed, you guys are doing a lot for defending yourself in court. A lot of other people are just also not as aware of what you guys have studied and learned and are trying to perfect. And it's always good to see there's a lot of solutions out there. And, some of those take a turn for the worse, but some of them have worked out in the long run for people. But, a lot of people on the, Second Amendment side of the fence are a little hesitant to, fight that system, at least in the courtrooms. Just like many people do, they kind of just take that ticket and pay it and hope it's not a mark on their license and don't realize there are defenses also on that battlefield as well. Speaking for the Oath Keepers, I don't know if anybody's really following what they're trying to do, but they're definitely, assembling men for their own states as well, which is actually good to kind of see. they're trying to avoid the whole militia mentality to where, you know, it's gotten such a bad persona over the last decade or so. You know, if you would ask 200 years ago, everybody's like, well, how's the militia going? Well, I'll see you at the meeting. You know, yeah, everybody was part of that. You know, that was the neighborhood, the town looking out for their family, friends, and community. You didn't really have such a police state back then, but now with such a police state that we have today, I mean, I know you guys can see it with your own eyes. I mean, people are getting beaten, harassed, hassled. You know, some have died. There's dubious amounts of, you know, force that they feel that they need to use on the people when they should be there, as we know, as our servant and masters. I mean, as far as I know, our taxes go towards paying for bettering society and making sure that, you know, the loonies out there shooting people aren't on the streets. But as far as us everyday citizens, that is the militia, and they need to protect themselves in other aspects as well. You know, hopefully, you know, we've seen other common law cases over time that does state that if a false arrest is happening, that's an assault, and you have every which right to defend yourself if you're being assaulted or your property is being threatened or you're threatened with bodily harm. And that includes handcuffs, that includes being tased, beaten with a baton, shot at. And, you know, over time, Randy, as you know, I've been trying really hard to be some sort of bridge between these two battlefields and show that one is the other and one needs the other just as much. You know,
that's right.
These people are out there every day getting tickets and dealing with law enforcement, and you guys are in the same zone. And unfortunately, some have become a little harder and a little more upset and feel, you know, the time has come to where there's going to be a huge divide in this on this land in the near future. I mean, everything we see, the law enforcement doubling up their protections as far as like MRAP vehicles, you know, armored vehicles, mine-resistant vehicles. None of us have mines that I know of, but for some reason the sheriff thinks he needs one. You know, there's different soldiers all over the bases, UN troops just as usual. They're still training Chinese troops on our property because I don't think American soldiers yet would really go after and attack American citizens. You know, a lot of people are worried that some sort of event may occur in the near future. Of course, most of us pray that nothing like that happens, but, you know, you always got to kind of look at some of the clues. We've been kind of worried about this upcoming power outage drill, which has always been a huge possible catastrophic event if the power went out like it did on the East Coast, was that 5-6 years ago, I believe, for a good week or two. You know, a lot of people didn't make it too far, and a lot of people had to be sent off and sheltered and, you know, put in arena domes, and the government, you know, tells you what to do and what to eat, and you've got to stay there for the next couple of weeks. They'll pull you out of your house because you're not allowed to stay in your home, you know, due to the fact that they want to seal off this area so that they don't have to worry about anybody because there's a blackout. That's just another causality of martial law, if you ask us. So, you know, I hate to babble on, you know, but these are some of the concerns that everybody should have. I mean, it's unfortunate. It's sad to see the way that this country is turning into in such a short period of time. Just, you know, this year alone in 2013, we've seen leaps and bounds of our Bill of Rights just being trampled on. And I know, and you guys all know and understand for the most part, you know, it's a corporate constitution that they're going on. They're not even the same entity everybody's taken an oath to uphold and protect. It's a corporation. They think they're still, you know, pledging an oath to their forefathers and the Republic. And unfortunately, dealing with as many veterans and active duties as I deal with, it's just really hard to kind of break into this whole thought process and try to explain to them, hey, you know, somebody else is basically, there's already been a coup. The coup happened a long time ago. You know, people are worried about another military coup happening in the near future. Well, if it could bring the Republic back, I'm not going to deny that. I'm all for it. But I don't know. A lot of soldiers are being disavowed, and a lot of soldiers are being removed and demoted. And the way I see it, the guys that are standing up and wanting to do something to fight the current tyranny are being removed from their jobs. Nobody wants to really talk about it, and, you know, the soldiers are waking up, I feel, but what do they do at this point? The more they talk about it, the quicker they're going to get removed from the positions they hold. So they can't do anything about it if they talk about it.
Say, Brian, may I ask you a question?
Please do.
This is Chris in Las Vegas. I'm a former Republic meter. In fact, I was the Nevada Supreme Court Justice here in the common law for the Return of Republic until they ran me off. But you're down in Arizona, and I know you mentioned Oath Keepers. I heard on J.R. Muller's show on republicbroadcasting.org network yesterday morning, or maybe it was the day before yesterday, that someone had overheard at an Oath Keepers large meeting in some state, I presume it's out west, either here in Nevada, Arizona, or California, is my conclusory guess, but they had one of their members where they were imbibing in adult drinks, and as he drank a little more, he began to talk with a Russian accent. So apparently he was a Spetsnaz infiltrator, speaking to the invasion of foreign troops onto our country that are hiding in various formerly abandoned military facilities and free trade zones around the nation. And I was wondering if you would consider possibly, through Randy, communicating with me. I'm near Las Vegas and also have land that I've been beaten the zone Nazis, and you have a Pike County with under private grants of land made patent. So you might want to share some things with me, and maybe I can help you guys with some things there.
Just to correct, I'm actually in one of the most more corrupter states of the Union. I'm in Illinois.
You're in Illinois. I thought you were. Oh, yes, so, I know about Illinois. I apologize. I thought you were in Arizona, but you said
for some reason, God dropped me here, and I think there's a lot to do in this state. Not that all of them don't need some help, but it's not so bad, learning the ways of the corrupt out here. At least I know, what kind of games everybody else is dealing with, but it's in a lot of frequency here in Illinois, especially trying to be such a proponent for the Second Amendment. We're just barely have gotten concealed carry passed, and even that's got a lot of issues with that. But as far as the other question that you had mentioned about infiltration and such, in many aspects of anything working towards the betterment of this country, or at least anybody who's analyzed who the real domestic terrorists really are, and I don't really have to say too much about that. Most of the people here should be in that same train of thought. A lot of them are wearing suits over there in D.C. As far as infiltration from other countries and such, you've got to kind of give people a benefit of the doubt and keep an open mind. I've seen many different, the position that I hold now, I actually removed myself as first lieutenant of the Illinois Sons of Liberty about 2 years ago and gave it to a veteran that was better qualified than I was. At this point, I've actually retained more of a HR recruiting type position for the last few years, but I'll still have some sort of administration abilities if and when this shit ever does hit the fan. Pardon my French. But that being said, I've come across a lot of different kinds of people, and America is known for being the cusp, the last bastion of freedom for other countries as well. So just because somebody had an accent doesn't say a lot for me. Hell, if he was KGB at one point and moved over here as a civilian, let me know what I need to know. The guy's probably got a plethora of information I'd love to use. So I've met a lot of different aspects. I know people from every branch, from major generals down to grunts, and to hear someone else with an accent, I can only try to keep an open mind until they do me wrong. I don't trust everybody, and don't tell them too much kind of thing. But hey, if he's there investigating and you're not doing anything wrong, you don't really have so much to worry about. Oath Keepers, to me, is not anything more than a lot of law officers trying to wake up other people and say, hey, we smell what's cooking in the White House, and it's time we start using all this information and actually doing something before even the sheriffs don't have something to turn to, because as you know, they're one of the last bastions of freedom. They are the true voted-in constitutional authorities of their land, regardless of which constitution you happen to be following. They are elected by the people for the people, and they're there to protect them. There's been plenty of other cases, Supreme Court rulings, where that's proven fact. If federal agents decide they're going to confiscate guns in New Mexico, and the federal sheriffs want to stand against them, they can do that. And Supreme Court cases have ruled in the sheriff's favor. If they want to kick out the Fed, they can. So they're just trying to get more sheriffs on board, realize that they have that power to fight these unconstitutional boundaries and do something for their people that elected them in the first place. And, one avenue that I've been trying to teach my guys as far as the Second Amendment supporters in Illinois, and mind you, there are thousands of them, is to really get to know their sheriffs, because in this corrupt state, we're not going to get the governor to approve, constitutionally, even though it's a corporate constitution, the Illinois Constitution does leave room for an allotted militia, but we're under the control of the governor, and it doesn't really account for the, civilian end of it in Illinois. So what can guys like us do, in a poop hits the fan environment, and that would be to be deputized by our local sheriffs. So we're doing a lot to try to get our sheriffs on the good guys list. I don't know if you've seen the Oath Keepers Oath, but their whole premise is that they will not disarm the people, they will not do any illegal searches and seizures without, justifiable cause, and a variety of other lists of things the Oath Keepers won't do.
I'd absolutely say that. I had the good fortune of being at the foundational meeting with Stuart Rhodes, Richard Mack. There was Black Robe preacher, Pastor Garrett. I can't think of his last name, but that was here in Las Vegas probably 5 or 6 years ago. But it's a great organization, and Richard Mack is doing great things. I have both of his books, and Stuart and his group are doing a pretty good job of staying on the right side of the law as opposed to the wrong side. But whenever you got 72 or 77 different items where you can claim that you're a threat to the government, it's pretty hard to avoid being at least a couple of those things for anybody.
It's really just good to see law enforcement. Well, there's still good guys in law enforcement. I feel overall the general populace has lost a lot of faith in what the police are, especially in more of an urban environment where, the police are so vastly outnumbered as opposed to in the country areas where you might get to know your sheriff or get to know a couple of the locals, It's good to see good guys standing up, and I hope there's a lot more of that. I've always felt that there needs to be someone who watches the watchers, and there needs to be a better psychological evaluation on these people, and you can really determine who good guys are and who potentially bad guys are. And, I think there should be more of a reward system instead of a punishment system for police officers that see somebody acting outside of their capacity or abusing their authority. Instead of the watching out for our brother's environment, we should be watching out for the people. That's not my brother because he went outside of his constitutional oath that he took in the first place. If you're kicking down doors without a warrant, there's a problem. Period. It just shouldn't happen, but cops do it all the time. And, no, I chased him into the house, or he was firing a gun from inside the home. They lie all the time. But hopefully it becomes more of a trend to, be honest, or more honest and constitutional as possible. I've always felt that they should have some sort of, live recorded video cam on them at all times so that, they should be rewarded for good behavior and doing the right thing and should be penalized or fired for going outside of their constitutional capacity. They don't even teach them the Constitution. Most police officers couldn't go back and repeat most of the Constitution, to be honest, and that's unfortunate. Luckily, we've got scholars like you guys that could pretty much tell you the Constitution backward and forward and tell you a little bit about UCC code and common law as well. It's always good to hear. As far as I've been hearing from the sheeple anyway, most feel that, common law has pretty much lost it's not viable anymore. It no longer has any precedence over other laws.
That's because the people don't demand the common law, and even state court and circuit court and superior court claims that they are common law court. Then if they are claiming that it is common law court, then we can demand it, and so I demand, basically, and I don't want to follow any of these court rules, and I just move with the declarations and affidavit, and if they don't rebut it, default. Now I demand from the court a default judgment.
if you end up in a courtroom, you can pull a conflict of interest and declare a courtroom a common law courtroom if you have all the oaths of office for all the officers in the room. And the judge and the prosecutor and the bailiff and the secretary or whoever's typing. Is that true? Anyway.
Well, basically, the true common law court should be a Article 3 court. And I know somebody who accessed that, and they actually, a private attorney general did that, and everybody went to jail. Every single one of them as a defendant. And there was a federal judges and county officers. An Article 3 judge actually called the grand juries, and grand juries was pulled from the county commissioner, and they had a grand jury hearing, and all of them got indicted, and all went to jail.
See, we need more cases like that happening all across the country. Just prove.
So there is a Article 3 judge, but people just don't know how to access that, and certain private attorney general knows how to do it. So there is a case actually, it is published, and I think you could still read it. It's in a Texas case, and I believe he started with a traffic case, and then he found a whole bunch of people doing all kinds of crimes, and he started adding judges and all kinds of criminals into the case, and then they all went to jail because they were doing human trafficking, and they were selling children in the black market. And can you imagine? It started with a traffic court case, and then the whole thing just discovered. So he ended up adding more and more and more, and then he demanded a trial by jury. And so then the article judge, actually a clerk of the court, they pulled the grand jury out of the commission, the electors, and then they held a common law court, and they all got indicted.
Well, I'd like to see more of that happen across the nation. I was working very closely with the Rusev, governor of Illinois, as far as the security team for a couple of years. They still consider themselves pretty active, but I have not been going to the meetings for almost over a year now. We had some similar cases. People were fighting a lot of foreclosure out here. I was actually a bailiff for a couple of common law court cases in the past. Not really sure how successful they were with that. You're always trying new avenues. But there were a couple federal cases I've actually been in. If you guys were part of RUSA, you probably know Sharon, who I'm talking about. She was very well versed in those ways that you're speaking of, and there's some pretty excellent things that you guys, have access to. I think more of the world needs to know about that. I know you've been suppressed and infiltrated. Are you guys part of the new group Reforming the Republic as well, or?
Well, there are a lot of stuff going on right now, and the Pentagon is joining, with the people like private attorney general and grand jury, and they want to clean up this mess. So they definitely are moving underground, and I think a whole bunch of the people in the government is going to be arrested. So they're working on it.
For that.
And I definitely believe that they are seeking for documents that we use, and I don't know. I have a feeling that they are going to create, many private attorney generals, and I think they're going to come in as prosecutors. And I think they're going to do massive arrests. I believe they're working on it.
There's another group that had approached me. They were looking for environmental marshals. to do some arrests for people on crimes against humanity and polluting the planet. And they had approached me and asked if I wanted to sign up and be one of the marshals that would be able to take these common law arrest warrants and start doing some citizens arrests. And nothing has moved forward on that at all, unfortunately. But when the day comes and you guys finally have that piece of paper, feel free to get a hold of me. I'll be happy to do some citizens arrests. Let's catch him while he's at home in Illinois.
Yeah, if you want to get involved, you could actually form the juries and grand juries in your area, you know, and definitely there are groups that are supporting. And one of the groups that right now is actively going and forming a grand jury right now and then brought some crime against the judges. So it's they just filed. So you may want to, you know, to pay attention to this particular website. Let me find out what the name of the website.
While she's looking for that, Brian, is there some websites you want to throw out for people to get active with their local militia groups?
There's so many now. Everybody wants to kind of be, you know, running something on a national level, which I've always felt, you know, although the idea is there to kind of bring some people under an umbrella, it's really comes down to being a matter of the state for the state of the state. So, you know, everybody knows how to look up Google. I mean, look up your state militias and, you know, do some of your own investigating. I can't really speak for all 50 states. I know we have a great couple of groups actually out here in Illinois. I'm familiar with at least, you know, 40 other groups across the country. That's not me, is it? You guys hear that?
Say it again. What was it?
Did you hear that clicking?
No.
No, I don't. You got some friends listening from the NSA, I would imagine.
Yeah, most likely.
So this is a website called nationallibertyalliance.org.
Yeah, that's a good website to get involved. That's where you can be a jurist as well. Do you know anything about that group, Brian?
I'm unfortunately not. No, this is the first time I'm aware of that. I've heard about it.
Yeah, they filed, I think, 3-4 judges against them. So, you know, go there and see what they're doing.
Yeah, absolutely. I'll get on my laptop here in a little bit. Obviously, the NSA will probably be reading it as well when I'm
They're moving with the quo warranto.
And is this somehow validated where they can actually have the true citizens arrest taken care of, or what?
Oh, yeah, they have a grand juries now, and they are actually demanding the court to basically make a room for them so they could come in and adjudicate the case.
Well, who becomes the arresting authority, though?
I think grand jury and the private attorney general. You don't really need anybody else because private attorney general is a prosecutor. It's a federal prosecutors, and they could prosecute the crime, actually. We don't need any other government officers because that is the highest authority in republic. And prosecutor in republic, you know, be able to arrest the criminals. And in case if they don't do, they always could contact the U.S. District Attorney. And U.S. District Attorneys, they do not want to get involved prosecuting because they are same bunch. So usually, like, you have to demand the okay and give me a green light, and they do give a letter and say, go ahead. And then that's it. Then U.S. Marshal moves their finger and arrest them.
So U.S. Marshal is the arresting authority figure that would take
care
of
U.S. Marshal is the authority to you know, it's all in the law, and they move by the codes, and it's all said in the United States Code who could do what, and so that code is designating, you know, what officials could do what, and you know what court could do what, and so you got to really pay attention to those United States code. You know, those codes are actually created all according to the Constitution.
And those are still generally accepted amongst the magistrates that are acting as judges?
Oh, yeah, there's Article 3 judges.
Interesting.
So what I'm hearing is that you got to file the case and through the Washington, D.C. Article 3 court, and then that court will actually assign the Article 3 judge, and then they will come around to the state near you where the federal court is located, and then they will adjudicate the case there.
Interesting.
Yeah, so I think Rod Class is talking about he found the district court in the Washington, D.C., so he's going to Washington, D.C. and filing cases. And then when he files the case, I think that they actually send it to the federal courts, in your district, and that's where he's going to show up and have a trial. So there is an Article 3 common law court is running. It's just not often because people are not seeking for it. But the Article 3 judges are there. They are waiting for people to come in.
National Liberty Alliance?
Huh?
Was it National Liberty Alliance?
No, that's the recent group. He started forming about 6 months ago. He basically stated that the Supreme Court is allowing the fourth branch of the government, which we the people could create a grand jury, a common law court. So he's been really acting, really focusing, and he's creating a grand jury right now. And I think good things are happening. I think government is getting involved and together, and they want to clean up this mess. And I believe it's the order that comes down from the Pope. And Pope created that motto, something, the order, and he's committed to clean up the crimes right now. So I believe the Jesuits are taking the orders,
We shall see. They couldn't act much faster, though. I mean, this stuff needed to happen 2 years ago.
But once it starts happening, it'll be really fast.
But can we backtrack? Can we backtrack and literally get him for treason and everything he's done gets erased, the NDAA and the Patriot Act and stuff?
All those codes, actually, it applies to the federal government officers anyway. It doesn't apply to any of the people. You got to read the Constitution, because Constitution says that no legislature shall exceed 10 square miles. So what does that mean? Washington, D.C. and all surrounded, let's say 3.5 miles all around it, and that's it. That's where the law should stay, and it shall not exceed that area. So how they exceeded that area? Only through the corporation. That's why they put you into a corporate entity and tied to that 10 square miles. But did they get your consent? No. So are you bound by any codes and regulations? No. It doesn't apply to us. Okay?
What was your name again? What was your name, man?
My name?
Yes.
Oh, Gloria.
Gloria, it's been a good talk, and Randy, I know you're still here, too. I have to go.
Hey, thank you for coming tonight. Anytime you want to come on, let us know. Keep us updated with things going on. Let us know. Okay? Reach out.
Stay in touch with me as well. I appreciate the talk.
You got it.
Take care.
All right, you guys. We're going to end this with Gloria. If you want to tell us, you certainly don't have to, how you got your invitation to court.
Oh, I was speeding, and this particular road, the state trooper said, that's a jurisdiction of federal area, and he's not a state officer. He's a federal officer. So he gave me, he said, do you have a license, insurance, and registration? And I said, I don't. And where is the law that I have to get all these things? And so I gave them my affidavit that I have. I recorded it, and it has a picture and everything. So I said, this is my ID. So I gave them 20 papers that is recorded and was served to the United States Transportation, the commissioner, and I told him that this paper was served, and I am allowed to, have my own private plate, and so then he took my paper, and then he used my given name, and he pulled the driver license record. And I said, driver license, I do not consent. That's just a competency of the certificate the government gave me that I am good to operate the vehicle on the road, but that doesn't, apply to any jurisdiction, so that shall not be used as my ID. And he pulled out my social security number, not mine. I mean, the straw man's social security number, and he actually created a ticket. And he said, "Hey, here is a ticket." I said, "I won't take it," And you're using my given name, and you're pulling the entity that is in the driver license. I said, I do not consent. So if you want to drop the ticket on the floor, or don't you dare to put it into my car. And then he said, here is a ticket. I said, no, I won't take it. That's not me. And then he said, okay. He opened the car, and he pulled me out of the car, and he handcuffed me. And then he took me to the precinct, and he said, oh, you cannot take this car. You have to have a license. You have to have a registration and insurance. Otherwise, you cannot pick up the car. So the towing company towed away. So I went to the precinct, and they put me into this metal cage, okay, and I was they were writing some stuff, some contracts. So I was giving lecture about Constitution and Bill of Rights and how they're violating my rights and blah blah blah. And so then they pushed me this paper. I said, what is that? Oh, read it. Before you sign it, read it. And at that point, my mind cannot even digest not even one word what's written. And what I know is, okay, I got to get out of here. So I'll just give it to me, and I'll sign it under duress and threat and coercion. So they gave me the paper, and I signed it. I go, did you read it? I said, no, I do not understand. It's funny. And then they asked me, are you a U.S. citizen? I said, no, I'm not a U.S. citizen. I'm an American citizen, and I'm one of the people of Pennsylvania, So then after that, they actually dropped me off, and the next day I have to buy, insurance for the whole entire year. Basically, what the whole damage was $2,000. So I actually put it on the affidavit that this man, there's no law that I need an insurance and registration, and here's a case laws, and he has no oath and bonds that he display, and I don't know this man, and so basically he damaged me, and he has to pay me. So I declare the declaration, and then I, refuse for cause, and here is your original contract paper, and I'm returning everything. So I returned, and that was 23 days ago, and they haven't contacted me, So that's the story.
I got to say, I'm totally proud of you, Gloria. You're one person, if I was a cop, I would not want to tangle with.
Yeah, they knew that I am not an easy target because I knew a lot of stuff, and I basically told him that, hey, I was on the way to get sworn in as a private attorney general. I said, I'm going to sue you as a private attorney general, and you get ready because your job is going to be gone. Okay, and you have a chance if you want to drop this case. But if you don't want to drop it, go ahead. I have no problem. So yeah, Then he said, what do you mean, private attorney general? I said, yeah, I was going right on to the next town to get sworn in, and you pulled me over. So I'm definitely becoming a private attorney general, and I'll sue you on the Title 42 and 1983 and 1988 for crime. You violated my rights, and you don't have a warrant. Oh, I don't need a warrant. Oh yeah, okay. Why don't you read Fourth Amendment? What he says, you need a warrant, and you need an oath and affirmation too. And you took my plates and you took my car.
Did he actually open? Did you have your car unlocked? That he was able to get in it?
They just picked it up and towed it away.
And the way he got you to get out of the car was what?
Oh yeah. He pulled me out physically.
Oh wow. Okay.
I said, I'm not leaving my car. I said, this is my private property. I'm not going on a public land. And then that's when he opened the car and pulled me out of there. So I said, do it. You do it, and I'm not walking out. Okay. So this way I could sue you. So now he's totally guilty because he pulled me out of my car and he handcuffed me. And then he retained me for an hour and a half. So now I can sue him, in federal court.
So are you going after him then?
Oh, yeah. Yeah, I'm going to go after him and sue him as a private attorney general, yeah.
Well, you got to keep us posted on this case. This will be outstanding.
So, yeah, because when normal people sue, I don't think people are not going to get a remedy on a Title 42. Basically, Title 42 action, when you are persecuting a the public officer, I think it works better as a private attorney general.
How did you become a private attorney general? Is that something you can explain in a couple of minutes? If not, we might hold it over till next week.
No, this cannot be on a public station. I don't think the government wants me to, teach how to become a private attorney general.
Okay.
So, people could contact me privately, something. But, so there is, it's right on the Constitution. It says the Congress shall grant letter of marque and appraisal. And so basically Congress has to grant anybody who wants to become private attorney general. And we do not have to go to school for 5 years, 10 years, whatever, and study law. Basically, people have the right to move the court on based on Bible. Okay, so Bible says if you have any issue, you send out a notice to the other party, and you go to your brother, and you seek for remedy, and, whether the other person is going to apologize to you for what they've done wrong, otherwise you punish them, and that's the only way to deal with this issue. So we the people just have to do that and default that the other party did not, answer the affidavit. And so now you have a right to move with a default and judgment. That's it. So we don't need any laws. We don't need to know any laws. All those regulation codes and, court rules, that all applies to them and attorney, not us. People should not go into the court and be a slave of those court rules. You declare that the judges are bound by giving common law to me, and he has a sworn oath of office that he supports the 7th Amendment Constitution, that the common law shall be given, and over $20 trial by jury shall be given. Now you demand. So common law court is for me is I am moving with the affidavit and declaration, and the other party has to answer. That's it. You know, don't complicate it ourselves. So it doesn't matter, like mortgage case or credit card case, any case, you could demand common law, period. You got to demand it. Got it?
Well, I think this is a good spot to wrap. Thank you so much, Gloria. You got a lot of great information there. We had a tax call tonight. Thank you, everybody who commented, had questions, who spoke, who added to it. It's good for everyone. Follow us on Facebook, facebook.com/42action. Make sure you share our website with everyone you know and get them registered. It's absolutely free to register there. They have access once registered to everything within the site except for a few documents there on the front. And if they have any questions or if you have any questions, you want to get in touch with any of the speakers we had tonight, just send an email to support@42action.org and just tell us who it is in the subject line. And if you want to tell us something briefly about your case or what your question is, we love to hear it. We like to know what people need help with, need remedy with. And with that, Chris, Gloria, Dave, if you're still on, Brian, Patrick, thank you to everybody. Melvin, I know you're gone, but thank you. God bless everyone. Have a super week.